Okay, welcome back, folks. We're listening to live testimony in the trial of a Texas police officer sitting in the defendant's chair on charges that he shot and killed a 15-year-old during some law enforcement activity. Bottom line here, the officer said that it was defense of another officer who he feared was going to be rammed by a vehicle. The surveillance footage, the body camera footage, I should say, shows a different story. It shows that the vehicle was headed away from the officers. So a factual discrepancy here. We're going to try to break this all down. A lot for the jury to look at here. Bottom line, Eric Weitz is an attorney in Philadelphia. He's here with us today on the Law and Crime Network. Eric, what do you make of this? I mean, is the jury just going to take a look at the video and say this officer misperceived the situation, he should have known better, guilty?
You know, this is unfortunately becoming a classic type of case that the public is hearing more and more about. And when a police officer who's no longer with the police force takes the stand and tries to tell everybody to believe what he's saying and not what their eyes are saying, he's got a tough road to hoe. And I also believe in this case that his former partner got on the stand and has said, or he's going to say, that I didn't fear for my life, and I was there, and it didn't look the way that Mr. Oliver's describing it. He's got a very steep hill to climb here.
I agree, but one thing we talked about is the nature of time here and how this recording from the body cam allows prosecutors to really slow this down in a way that we wouldn't have seen in the years before body cams.
It's certainly interesting, but what happens is sometimes when the prosecution goes too deep into that, it aids the defense, because as you slow things down, as you kind of go step by step and walk through it, even with the witness who's currently on the stand, where they're talking about could it be environmental gunshot residue versus primary gunshot residue, you're giving the jury more to become confused about. Not that the jury is ignorant, but you're just throwing a lot at them for them to consider in a very short period of time, and then they're going to get that charge about a reasonable doubt. Sometimes that the strategy of kind of going very detailed piece by piece could be aiding the defense.
Yeah, I mean, look, the state's throwing a lot of evidence in. Sometimes the state just does it to leave questions, leave questions unanswered. I've heard of cases where jurors had slam dunk cases, but they said, well, the state never tested that DNA, even though there were all sorts of other really key pieces of evidence. So we'll acquit, as strange as that is. Maybe the prosecution fears that in this case. We're going to take a quick break. We will be back live with more testimony in just a moment. We are live, folks, in the Roy Oliver case out of Texas, the case of a police officer accused of killing a 15-year-old who was a passenger in a vehicle leaving a scene where that officer had been called for a response. Eric Weitz is an attorney in Philadelphia. He's with us today on the Law and Crime Network. Eric, we've got all this testimony right now about gunshot residue and whatnot. We talked about this a little bit more, but to hit the nail on the head, why is this even important? I mean, is it really contested who fired the weapon here?
Well, I think, and correct me if I'm wrong, but I thought they were talking about gunshot residue on the hand of the victim.
Okay, so if they're talking about that, though, how is it relevant to whether or not this officer fired the gun?
Well, if they can raise a question that there was something about the circumstances that would have led the police officer to fear for his life or fear for his colleagues, whom he claims he was trying to protect, they can raise doubt in that manner. The problem, which this witness keeps saying over and over and over again, is what was found, I believe, on the victim's hand, or the gunshot residue they're talking about, is not primary, but something that could come from environmental factors, or if, as the prosecution established right before they sat down, if somebody shot a weapon and then used that hand to touch something else, and then shortly after, they're going to pass off this secondary residue.
Yeah. Okay. So those are the key elements that we're looking at with this witness. We're going to be back live with more testimony in the Roy Oliver case when we return here on Law and Crime. Wrapping up testimony there from this witness, at least, about whether or not the victim had any gunshot residue on his hands and whether or not he could have been involved in firing a weapon. in some of the moments leading up to the shooting from a police officer, the defendant in this case, Roy Oliver, which ultimately led to the death of that victim, 15-year-old Jordan Edward. Eric Weitz is an attorney. He's joining us from Philadelphia today on the Law&Crime Network. Eric, what did you sort of make from the overall trajectory of that testimony from that expert on the stand?
Trajectory, gunshot, I got it. So I got to tell you, I am shocked that the prosecutor did not ask a gift of a question. As I was sitting there listening to the cross-examination, I thought that the prosecutor had kind of set the stage for a wonderful redirect. And that is, there is one other way that a few particles of gunshot residue might end up on this child's hands. And that is if the child was struck by a bullet that had gunshot residue on it and put his hands anywhere near where he was shot. And I thought that was the prosecutor's way of letting the defense walk right into it. He never asked the question. But that is another way that a few particles of gunshot residue could end up on this child's hand.
Well, we're going to head right back to court. We thought this was going to be a break, but there's another witness who just took the stand in the Roy Oliver case from Texas. This is Heather Francis about to take the stand. She is a firearm and tool mark examiner. My guess is that we're in for more of that testimony that tries to match the bullets up to the guns. Let's listen in as this next witness is on the stand. Live testimony there from the Roy Oliver murder case in Texas. Again, this is a murder case along with 4 attached aggravated assault by a public servant charges. The accusation here that a police officer shot and killed a 15-year-old who was in a vehicle leaving a crime scene. Eric Weitz is a Philadelphia attorney. He's joining us here on the Law&Crime Network. Just before we take a quick break, Eric, look, we're seeing these bullets brought in. Again, is there any guess where this testimony might be going?
At the end of the day, I have to imagine that what they're trying to do is just simply match up the bullet that killed this young man with the bullet that was fired from the rifle that the defendant was handling. I don't know. Maybe they're trying to dispel the concerns that were raised with the last witness that maybe there were other bullets being fired in the area. I'm not sure, but they seem to be going a real long distance and taking their time to prove a very simple fact.
Yeah, I mean, certainly the state has the burden here, and the state wants to prove every possible thing it can beyond a reasonable doubt. We understand that. But a couple of other facts in this case, Eric, I want to run past you. There was a 911 call that there were some drunken teenagers. That's why police were even at the scene at the first place. And apparently the officers on the scene heard gunshots. They thought that they were coming from outside the house where they were called, but apparently those gunshots were actually coming from a nearby nursing home location. That's my understanding of how this played out. But if officers indeed believe that there was gunfire starting to break out here, does this make the prosecution of this individual a lot tougher for the state?
I don't think a jury is ready to say that it's okay for a police officer to just start shooting at a car because they heard gunshots and they don't know where they came from. I think that's probably a bit of a stretch. It certainly adds to the environment of what's going on, and that's why they're kind of going through this chronology step by step. But otherwise, it is concerning. But on the other side of the coin, when police officers pull up at a scene and you have 100 or 150 teenagers at a party, I think you probably want to be a little hesitant before you start pulling guns out.
Well, look, I mean, that sounds logical. That sounds well and good. But, we've talked about time, and I think the perfect characterization of this case is just how quickly it all happened. I mean, this rolled out very, very quickly, according to the video. The state wants everyone to slow it down and look at that video frame by frame by frame and say, oh, there was, this is the one piece that indicates that the officer did the wrong thing. The defense saying, wait a minute, look at this in its entirety. This happened very quickly. He had to make a split-second decision. Maybe it was the wrong decision, but he had to make it in the moment to preserve either himself or his friend. We're going to take a quick break. We'll be back with more live testimony in just a minute here on Law&Crime. Welcome back, everyone. Before we jump back into the Roy Oliver case here on the Law&Crime Network, I want to take a couple minutes to bring you up to speed on the news that broke this afternoon in the Mollie Tibbetts case. Eric Weitz is an attorney in Philadelphia. He's going to break this down along with me. Again, Mollie Tibbetts, the missing Iowa college student. her body believed to have been located. Investigators are basically saying they're 99.9% sure that it's her, but they're waiting for official confirmation with an autopsy and forensic tests. This missing college student, a young woman out for a jog apparently, when authorities say she was approached by a defendant, Christian Rivera, that he followed after her with a vehicle, then basically ran after her and then alongside of her. At some point, she, according to the defendant, said, "Leave me alone or I'm going to call the police." At that point, he doesn't remember much. He claims that he blocks it all out. The next thing he claims he remembers is that he's in his vehicle with some kind of a headphone earpiece of some sort in his lap. And that is when he claims he remembers that he had Mollie Tibbets in the trunk of his car. So what does he do with her? He takes her out to a cornfield and hides what turns out to be, authorities say, Mollie Tibbets' body. Now, Eric, we hear about defendants lapsing into these mental fogs all the time. Do we believe it, or do they literally black these things out?
It really doesn't matter whether what we believe. It just matters what the jury in this case is going to ultimately believe. The story lacks a great deal of credibility. The timing is not great, given kind of the public discourse going on right now. One of the other questions, though, that I presume the defense is going to harp on is that they're still missing this element of motive. We have a description of almost every other aspect that a prosecutor might need, but the motive issue is missing.
You know, that's always a great one for prosecutors to have. It's not required in every state. I've got to look at Iowa law to get myself caught up on whether or not they need to prove that in Iowa. But we saw during this first appearance in court today, Eric, the defense is really worried about the pretrial publicity. They tried to keep cameras out. The judge turned around and said, well, you want to know what? Look, defense, we have rules in this state that are similar to the rules in many other states that allow cameras. And people seem to follow these rules just fine. They are able to behave just fine in the parameters of these rules. So guess what, defense? This case is going out for the public to see Iowa justice unfold. But, you know, the defense did bring another point into this, and that is we've got officials all the way up to the White House commenting about this case because there's an undocumented immigrant involved. And look, does the defense make a valid point with that? That when you're trying to protect the defendant's rights and you've got the White House jumping in, does that make it a lot harder?
It comes up in every big case. The real issue is what impact has it had and what notoriety did the potential jurors actually digest? A lot of people don't watch TV and don't listen to a lot of what's going on. You just don't know until it's time to pick a jury. This is a local case. It's going to be covered by the local press in the county where the trial is going to occur anyway. But not just because of the existence of this network and others, I'm a big believer that we need to be putting this stuff out in the public at the risk of what others might comment, so that people don't feel that what goes on in courtrooms is such a mystery and it's shrouded in this veil of secrecy. It's important. Why the White House is commenting, that's a whole separate issue.
Yeah, look, I mean, I've said this all along. I've given speeches on this topic, and I've said, hey, look, the more we have access to courtrooms, the better the press is at covering these proceedings. The more the press focuses on legal issues and not just accusations, because the press has access to everything and is able to tell the legal story, not just what the police say happened based on their preliminary investigation at the crime scene. I don't understand how having more information about what is on the legal record hurts a defendant. What the defendants really need to worry about is what's sort of spinning in the very early days of the investigation before the attorneys get involved and before people get involved in the case that are bound by the professional conduct rules. At least that's my take. I mean, Eric, do you agree? Do you disagree?
It never ceases to amaze me when I pick a jury, the number of people that this is the first time that they have any insight into a courtroom or into the process. We don't really teach civics in schools the way it was taught decades and generations ago, and people don't have a sense of what goes on. So I think an argument can be made not only that allowing cameras in is not going to necessarily upset the apple cart in terms of that individual defendant. But I think to the extent that it gives us a better educated and more knowledgeable public about how the process works and what goes on, may also serve to allow the public to better evaluate those things they read and hear.
Look, I don't disagree. So let's move on from this. Again, we are following the Mollie Tibbetts case very, very closely. Bottom line, we've got the defense saying that cameras in the courtroom would prejudice a proceeding against the defendant. We have cameras and we don't want to prejudice his right to a fair trial, but we want the public to understand how justice works. At least that's my personal take for what it's worth. That was what the defense argued today. The judge basically steamrolled that defense argument and said, look, these charges are on the record. This case is on the record. Cameras are going to be present. The press can carry this thing. That's ultimately what came of that argument. $5 million bond here. If the defendant is somehow able to raise that, he would have to turn over a passport if he indeed has one, and would not be allowed to leave that local county in rural Iowa where this case is proceeding. We have further proceedings scheduled for the end of this month, and we will certainly do everything in our power to carry them live here on the Law and Crime Network. We're going to move on now, though, and get you caught up to speed on the top crime stories of the day while we wait for a break in the Roy Oliver case in Texas. So here's the top crime stories.
Here are today's top crime stories trending on lawandcrime.com and across the country. A deputy in Texas accused of sexually assaulting a 4-year-old girl died of what authorities are calling a prison suicide. 47-year-old Jose Nunez was found dead at the Carnes County Detention Center while he awaited trial for one count of super aggravated sexual assault of a child. Nunez reportedly sexually abused the child and threatened her mother, an undocumented immigrant from Guatemala, with deportation if she reported him. Nunez faced a minimum of 25 years in prison if convicted. A mother in Georgia who left her 3-year-old son locked in a hot car was arrested after reporting her misstep to authorities. 26-year-old Alejandra Suarez called 911 to report she unintentionally left her 3-year-old son in a hot car for almost 3 hours. The boy was taken to the hospital and later released in good condition. Suarez now faces one felony count of second-degree cruelty to children. Investigators in Florida hope to use the same DNA technology used to catch the Golden State Killer to help them identify the infant girl they found dead in a Gainesville pond in 2003. Using DNA testing, authorities were able to create a composite image of baby Jane Doe, who was found face down in a man-made pond too decomposed to identify. Investigators plan on sending DNA samples to a DNA analytics company, Identifiers, who will search thousands of DNA databases for a match. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Attorney Eric Weitz is with us from Philadelphia this afternoon on the Law and Crime Network. So, Eric, let's talk about that last piece there. Apparently, this snagging of DNA profiles and uploading them to these databases, which include a lot of the popular ancestry sites, apparently this is the new tool for law enforcement that we're learning from the Golden State Killer case and now possibly from this case of this unidentified infant that was found dead in Florida.
It's, there's a lot of controversy about it. And I guess it's whose ox is being gored when it's a situation where you're looking to identify a victim and you want to find that person and you're trying to, do everything in your power to locate them. It's useful. On the other end, if you're a criminal defendant and they're trying to use DNA evidence to match you up with a certain crime, you probably have a lot of concerns about the science and how all this data or the samples were gathered.
Yeah, I mean, a lot of times this boils back to a search and seizure issue under constitutional law. The general consensus, at least as it's floating out there right now, is that if the government gets a DNA sample, especially from discarded DNA or from a victim, there are statutes in many states that make it clear that they can use that DNA however they want. It's been codified by state legislatures, but the uploading it into these private databases, a lot of legal experts are saying, hey, look, this doesn't qualify as a search under the meaning of the Constitution. And that seems to be the current legal standard that the experts are spinning. So they're saying that these things are constitutional, that they can be done that way, but privacy experts are throwing a fit.
The rules of evidence and the rules of procedure have always moved slower than the pace of society. We still have rules of evidence in the courtroom that really don't apply anymore because, who really, will rely on newspaper headlines or things like that in a courtroom these days with the proliferation of the internet. But the pace of technology is moving so fast these days. The courts and the systems of our rules and interpretation of the Constitution just can't keep up with the way that our system presently exists. And it's going to be, and that in itself is going to be a continuing huge problem.
I understand. So, look, we're going to turn back now to the Roy Oliver case, and we're going to continue to look at some of the previous testimony in that case while court is on a break. There are people filtering back into the courthouse, so we're not quite sure how long that break is going to last. But in the meantime, if you haven't seen it until now, let's look at the body cam footage that was recorded of the shooting. Keep in mind the time frame, folks. You'll see just how fast this happened, and pay very close attention to when officers approached that vehicle, just exactly where the vehicle was moving. That's what's at stake in this case.
Hey, Hamburger, come here. Have a seat. Where do you go to school?
West Mesquite.
All these West Mesquite kids? Maybe?
Wow, son of Mesquite. Pretty much all the time.
Listen, don't do this again.
Yeah, this is a one-time thing, sir.
Mr. Rhodes, I'm Officer Gross, okay?
Officer Rose.
I don't want to see this again.
Yeah, you'll see this again. I ain't expected to get this
I know.
tight.
Hey, stop that car! Stop right there! Stop!
6061 code 2312 6463
That horse shot him around somewhere in the center area.
Stop! Copy 28. Charles Sam 7 Young 882. Charles Sam 7 Young 882. Hey, stop that fucking car! Stop that fucking car right now! That fucking car! You alright? Yeah, fine. You're trying to hit you.
64 Black Cat, southbound, Shepherd, 302. Standby. Station going towards...
Stop! Stop!
That's the body cam footage. That's what's really at play. This is the crux of the Roy Oliver case from Texas. Eric Weitz, attorney, joining us now. Eric, I don't know if that's the first time you saw that, but look, we've got the command to stop the car. The car continues to back up. It backs up and prepares to sort of take off down this this perpendicular roadway. In the process of that vehicle taking off, that's when the shots are fired.
Look, it's a classic civil rights case on top of anything else. When somebody is fleeing, unless they have brandished a gun or they're showing that they are severely risking the lives and health of the people around them, the police know they're not supposed to use this level of deadly force. It did not. Look, a jury's going to have to make a decision for itself, but this is not the first time I've seen it. And every time I see it, I'm looking for that threat that would justify, randomly shooting into a car full of kids. And you just don't see it.
Sometimes I hate to armchair quarterback these circumstances, but I have to personally agree with you that I don't see it in this one either. But bottom line, we're going to take a quick break. We will be back with more live testimony in the Roy Oliver murder case from Texas when we return here on the Law and Crime Network.